This video is another stark warning that you absolutely must do your due diligence when you're going to work with a company and part with money, particularly if they're going to do work on your house and particularly if it's a large amount of money. As I read this morning that yet another company has gone into liquidation owing huge sums of money. I read this morning that SME Broker Services International Limited has gone into liquidation owing more than £220,000 to 16 different creditors, including HMRC. Whilst many suppliers were left out of pocket, some of the largest creditors included HMRC, who were owed over £100,000, Lloyds Bank being owed over £44,000, over £35,000 owed to Nationwide Building Society, and the list goes on. So what do you do in this situation if you are left out of pocket by this company and then you discover that the director goes to set up another company with a very similar name, sending this one into liquidation and then setting up afresh? Many people will think there's nothing you can do about this, but that's not quite true, because the Insolvency Act of 1986 has various provisions to prevent just this thing from happening. Because as we all know, with company limited liability, the liability is limited with the corporate entity. And traditionally, the directors are not personally liable for those debts, save for certain situations such as this. There are two at least very interesting provisions within the Insolvency Act. Those include Section 216 and 217. Section 216 of the Insolvency Act reads as follows. This section applies to a person where a company, the liquidated company, has gone into insolvent liquidation on or after the appointed day, and he was a director or shadow director of the company at any time in the period of 12 months ending with the day before it went into liquidation. Then it goes on to describe what company name is a prohibited name for the purposes of this section, which will become clear very shortly. For the purposes of this section, a name is a prohibited name in relation to such a person if it is a name by which the liquidating company was known at any time in the period of 12 months, or it is a name which is so similar to a name falling within paragraph A as to suggest an association with that company. So let's pause there for a moment. So let's say company A goes into liquidation because it is insolvent. Let's say the director then decides to set up a new company and just append something to the end of that company name, but is otherwise very similar and virtually identical. That would make that a prohibited company name for the purposes of this section, for reasons again that will become clear very shortly. Subsection 3 provides, except with leave of the court in such circumstances as may be prescribed, a person to whom this section applies shall not at any time in the period of 5 years beginning with the day of which the liquidating company went into liquidation be a director of any other company that is known by a prohibited name, or in any way, whether directly or indirectly, be concerned or take part in the promotion, formation or management of any such company, or in any way, whether directly or indirectly, be concerned or take part in the carrying on of a business carried on otherwise than by a company under a prohibited name. If a person acts in contravention of this section, he is liable to imprisonment or a fine or both. So let's just pause there and explain. A director sets up a company, company A, trades for a while, goes insolvent and into liquidation. Director doesn't want the responsibility for it, but the company cannot continue to trade. Director still wants to carry on business, sets up another company with a very similar name to confuse people that it's the same company and the same person with whom they are dealing. He or she then carries on business under this prohibited name. That is an act in contravention of this section of the Insolvency Act. And if found to be doing that, he is liable to imprisonment or a fine or both. So that's the liability of a director doing just that, setting up what we call a Phoenix company, a new phantom company that stands in place of the liquidated company. But there's more. Now we go on to talk about Section 217 and what happens to the debts of the original company. Now we come on to Section 217 of the Insolvency Act, which deals with the debts of the original company if the director sets up a new Phoenix company with a very similar name with the intent to keep on trading despite having the previous company gone into liquidation. Section 217 provides that a person is personally responsible for all the relevant debts of a company if at any time, A, in contravention of Section 216, he is involved in the management of the company, or B, as a person who is involved in the management of the company, he acts or is willing to act on instructions given without leave of the court by a person whom he knows at the time to be in contravention in relation to the company of Section 216. Subsection 2, where a person is personally responsible under this section for the relevant debts of a company, he is jointly and severally liable in respect of those debts with the company and any other person who, whether under this section or otherwise, is so liable. So bringing all of that together with Section 216 and Section 217, Under the Insolvency Act of 1986, those sections prescribe that a director may be imprisoned, fined, and made personally liable for the debts if he breaches those sections when wrongly using a prohibited name, which remember is a very similar name to the original company, when setting up a new company when the original one has gone into liquidation. So whilst this might sound quite complicated, in essence what it means is if a company goes into liquidation, the director cannot simply set up a new company with a similar name to just keep on trading, having avoided all of those debts in the first place. And back to the original story with SME Broker Services International Limited, it went into administration in January, and the manager director Alex Nichols also set up a new Phoenix company, SME Broker Services. So if you find yourself in the position where you are owed money by a company that's gone into liquidation, check out the directors and check out whether or not they are associated with any new company with a very similar name, and then speak to a lawyer to take formal legal advice, but feel free to mention this video to them and direct them that this is what you want them to look at when looking at the director, to make the director personally liable for those debts that they've tried to escape from the first company. Because according to these sections, they will be personally liable for those debts if they are found to be in breach of these sections of the Insolvency Act. So I hope that's useful for you. Please like the video if you find this content useful, subscribe, and I'll see you next time.